These are the 6 legal loopholes that landlords invented to make sure you never complain about your apartment, and most of them started in the 1970s. If you're renting right now, there's a good chance your lease contains at least one clause specifically designed to stop you from speaking up, going to court, or organizing with your neighbors. The wild part is, almost none of this happened by accident. It was engineered piece by landlords, real estate lobbyists, and the politicians they funded. So let's talk about how we got here. Before the 1970s, renting was basically the Wild West. Courts treated your obligations as a tenant as completely separate from your landlord's obligations to you. That meant if your building had rats, mold, busted plumbing, whatever, you still had to pay rent. If you didn't, you got evicted. No questions asked. San Francisco landlords could force longtime tenants out just by issuing an eviction notice and waiting for the sheriff. Landlords could raise rents as much and as often as the market could bear. There was zero government regulation, zero protection. But then tenants started fighting back. In 1968, a woman named Yvonne Edwards rented a property in Washington, D.C. from a landlord named Nathan Habib. She noticed sanitary code violations, and she did what any reasonable person would do. She complained to the Department of Licenses and Inspections. Inspectors showed up, found more than 40 violations, and ordered Habib to fix them. His response? He handed Yvonne Edwards a 30-day notice to vacate. Get out. That's what you get for complaining. But Yvonne Edwards didn't leave quietly. Her case, Edwards versus Habib, went to the D.C. Circuit Court and became the first legal recognition of retaliatory eviction as a defense. For the first time ever, a court said you can't kick someone out just because they reported you. 2 years later, in 1970, another D.C. case called Jovens versus First National Realty established something called the implied warranty of habitability. Basically, the court said if your building has 1,500 code violations, yeah, maybe tenants shouldn't have to keep paying full rent. Revolutionary stuff, apparently. These were massive wins for tenants, and landlords were terrified. Because if tenants could complain, withhold rent, and organize without getting evicted, the entire power dynamic shifted. So the real estate industry did what it does best. It went to the legislature. And that brings us to 1971 and the first major loophole, the Urstadt Law. This one's a masterpiece of political engineering. Governor Nelson Rockefeller and his housing commissioner, a man named Charles Urstadt, who was himself a major New York City landlord, pushed through a state law that stripped New York City of the power to enact any rent regulations stricter than what the state imposed. Think about that. The city with the most renters in the entire country was legally barred from protecting those renters at the local level. Decisions about New York City tenants were now made by upstate legislators, many of whom represented districts with almost no renters. And those upstate legislators? Way easier for the real estate industry to influence. Charles Urstadt later wrote that dozens of elected officials from both parties quietly thanked him for the political cover his law provided. These same officials would publicly rail against the law, call it an outrage, and then do absolutely nothing to repeal it. That law is still in effect today. But Urstadt wasn't the only thing that happened in 1971. That same year, Rockefeller signed vacancy decontrol into law. This was loophole number 2, and it was devastating. The concept was simple. Any rent-stabilized or controlled apartment that became vacant would automatically be deregulated. The tenant currently living there kept their protections, but the second they moved out or died, the apartment went to market rate. Forever. Between 1971 and 1974, somewhere between 380,000 and 500,000 rent-regulated apartments in New York City were deregulated. Rents on those units shot up an average of 52%, even though landlord operating costs had only gone up 7.9%. This created what advocates later called the eviction bonus. Landlords now had a massive financial incentive to get tenants out by any means necessary, because an empty apartment was worth dramatically more than an occupied one. In 1974, Governor Wilson signed the Emergency Tenant Protection Act, which ended vacancy decontrol and put some of those units back under regulation. But the damage was done, and the playbook had been written. Loophole number 3 came from the same era. Individual apartment improvements, or IAIs. Laws passed in the 1970s allowed landlords to raise regulated rents if they spent money on upgrades. Sounds reasonable, right? Here's the catch. A landlord could raise a vacant unit's monthly rent by 1/60th of the renovation cost, and they didn't have to prove the work was actually completed. According to the state's Division of Homes and Community Renewal, roughly 167,000 units were pulled out of rent regulation over 26 years using IAIS, often combined with other programs. Housing experts called it the most common and most easily manipulated path to deregulation. Now here's where it gets personal. Loophole number 4 is tenant blacklisting. Also born in the 1970s, these were databases tracking tenants who had appeared in housing court for any reason. If you ever fought an eviction, withheld rent over code violations, or even just showed up as a defendant in a frivolous case your landlord filed, your name went on a list. And once you were on that list, good luck finding a new apartment. Nearly 2,000 background screening companies operate across the country today, pulling in $3.02 billion in revenue annually. The fear of being blacklisted was so powerful that many tenants simply stopped asserting their legal rights. Why fight your landlord in court if doing so means no one else will ever rent to you? It wasn't until 2019 that New York made it illegal to deny a rental application based on housing court records. Attorney General Letitia James later cracked down on a company called Clipper Equity for doing exactly that, finding they'd improperly screened 25 applicants and denied 7 of them based on their court histories. Loophole number 5 is non-disparagement clauses. These migrated from corporate employment contracts into residential leases, and they do exactly what they sound like. They prohibit you from saying anything negative about your landlord publicly. Bad review on Yelp? Violation. Post about your mold problem on social media. Violation. The Consumer Review Fairness Act of 2016 technically made these clauses illegal in standard consumer contracts, but enforcement is spotty, and plenty of landlords still slip them into leases hoping tenants won't know any better. And finally, loophole number 6 is forced arbitration and class action waivers. Since the 1980s, landlords have increasingly required tenants to sign clauses that strip away their right to a jury trial and their ability to join class action lawsuits. One 2024 case in Pittsburgh perfectly illustrates the scam. A tenant named Adams signed a lease with a company called Lobos Management. The lease had a clause sending disputes to county court. But buried 3 paragraphs later, another clause quietly took that promise back and forced everything into private arbitration, where tenants have fewer rights, fewer remedies, and a bill if they lose. The landlord, meanwhile, kept the right to sue for eviction in public court. As tenant attorney James Fishman put it, landlords have long known they can do whatever they want, and even if they get caught 1 out of 50 times, it's still worth it. You have to be nuts not to be breaking the law because the chances of getting caught are so slim. So here's where we are. The 1970s gave landlords the playbook. Strip cities of local power. Create financial incentives to push tenants out. Let landlords claim fake renovations to deregulate apartments. Blacklist anyone who complains. Gag them in their leases. And if all else fails, force them into a private legal system where the landlord always wins. Some of these loopholes have been chipped away. New York banned blacklisting. Colorado banned jury trial waivers in leases. The Consumer Review Fairness Act went after gag clauses. But the Urstadt law is still on the books. Forced arbitration is spreading, and the nearly $3.02 billion tenant screening industry isn't going anywhere. The 1970s didn't just change how landlords did business. They changed what it meant to be a renter in America. And 50 years later, we're still living in the system they built.